Hello and welcome back. So clearly every week we're going to have some focus on AI, big data and blockchain. Sometimes I might use the term emerging technologies because at the moment that's the basket that those technologies fit into. And sometimes I'm going to look at technologies that are no longer new, don't fall into the basket we're interested in, but so that we can understand a little bit better what's happened in the past with a view to thinking about what we might be doing in the future. So as you now know, privacy is not a right in Australia, which means that companies don't, unless the legislation requires them to do, have a common law or constitutional obligation to look after people's privacy. Similarly, people don't have a right to claim privacy unless the legislation gives them that right. So the Privacy Act, 1988 Privacy Act, is the legislation that sets out the ways in which information can be collected, processed, dealt with if the Act applies. Now, the Act applies in most cases where sensitive information is being collected, in cases where businesses collect information and that business has a turnover of more than $3 million, in cases where the companies have voluntarily opted in to comply with the Privacy Act, and they might do that in their terms and conditions of service or their privacy policies, even though they don't have to comply, they can opt in and say that they will comply. And also if they are government departments. Similarly, and this slide is kind of a summary of the things that are relevant that I want to make sure that you're clear on. But as we discussed last time, there are other similar but different pieces of legislation, particularly at the state level, that deal with the collection and retention and dealing with information by state organisations across the different states, and also deal with issues like surveillance. So one of the important things to recognise is that the Privacy Act and the APPs don't apply to all businesses. And so one of the things you need to be doing in your assignment is standing back and thinking, is the kind of information we're collecting or that might be collected by this technology to learn or to process information in some way, are we at risk of breaching any of the APPs? And I'm going to discuss the APPs in a separate video. But there's another threshold question there is, do we as an organisation need to comply? Now, ASX listed companies on the whole do need to comply, but it is worth actually looking at the legislation or looking at the Privacy Commissioner's website, OAIC, so the Office of the Australian Information Commissioner, to see whether or not compliance is relevant. So before you can even get into the APPs, there's a couple of terms that we really need to be clear on. So the two terms that I really want you to focus on is what is personal information and what is sensitive information. Now, I like to think about them as a big Venn diagram. All sensitive information will be personal information, but not all personal information will be sensitive information. Not all entities will be required to comply with the APPs in relation to personal information, but if they collect sensitive information, then they will be required to comply, even if their turnover isn't at $3 million or more. So let's start with personal information. The trick to understanding personal information is it's information or opinions that could identify an individual or a person. So we're talking about natural persons here, individuals, not necessarily companies, etc. So data or information relating that could identify a particular company is not personal information as such. However, there might be sensitive information that belongs to a company, but we'll come back to that. So let's think about the kinds of information that is. So clearly your name, your signature, your address, your phone number or your date of birth, things that are directly connecting you, identifying you, are personal information. Credit information is personal information. So information about your credit history, but also information that links to your financial accounts. Your employee records are personal information. Photographs of you are personal information. Or internet protocol addresses or device IPs, things that can link an individual or their behaviors to a particular device, in the broader term, are personal information. Voice print and facial recognition biometrics, to the extent that they collect characteristics that make or identify the unique features of somebody's voice or face, may well be personal information. And going back actually to IP addresses and device information, location information from a mobile device, which could, when you think about it, reveal a user's activities, patterns or habits. This may well be personal information as well. Might be worth remembering that personal information relates to individuals who are living. So the Privacy Act doesn't cover the personal information of people who have died. So what is sensitive information then? Remember that all sensitive information is personal information. So it's a subclass of personal information. Sensitive information is personal information that includes information or opinions about an individual's racial or ethnic origin, their political opinions or associations, religious or philosophical beliefs, their membership of trade unions or associations, their sexual orientation or sexual practices. Criminal record is sensitive information. Health and genetic information is sensitive information. And some aspects of biometric information, so particularly when they're linked to health and genetic information. And as a general statement, sensitive information has a higher level of privacy protection than other personal information. So, as you know, as you've been progressing through the materials in this course, you're aware that the exponential growth in data generation, along with advances in artificial intelligence, facial recognition, biometrics, and other forms of the use of that big data, represents significant privacy challenges, or present, I should say, significant privacy challenges. There's always a weighing up here because the technologies offer significant public benefits, or could offer significant public benefits or business benefits, but they pose risk, particularly when there is an adequate governance or consent involved. And your whole first assignment is designed to help you consider, from the point of view of a business, what those benefits might be, what the risks might be, and to work backwards, essentially, to identify, well, what kind of technologies should we be omitting and not using altogether, or where can we put in risk mitigation strategies? So a lot of this has been in the public eye for some time. The Commissioner, from the Office of the Australian Information Commissioner, has acknowledged in a number of places. There's a speech, I'll put it in the references for the slides, that they made in 2022, which identifies that globally, the right to privacy is perceived as being a human right. In fact, it's a part of the Charter of Human Rights from the UN, but we don't actually have a right to privacy as such in Australia. And so at the time, they were recommending a restricted practices regime and the requirement in the Act to undertake privacy impact assessments to consider and mitigate risk to individuals and to have their practices audited by independent third parties. There's a great activity on the Canvas about thinking about a privacy impact assessment, and you might like to think about the role of privacy impact assessments in the process of risk mitigation for your assignments. So thinking about the ways in which these activities have been undertaken in the past can help you with this. A great case study is the Clearview case study. This is a joint investigation by OAIC and the UK Information Commissioner. It related to a case where a company called Clearview AI, had a facial recognition tool which he trained using 3 billion images that had been scraped from the internet. And ultimately it was found to have breached privacy laws in both Australia and the UK because it collected that sensitive biometric data without consent and through unfair means. But even still, the Information Commissioner considered that the tools that it had under the legislation were still insufficient to really remedy the harms that were caused. And one of the things that the Commissioner is particularly concerned about is automated decisions. So decisions that are made by artificial intelligence driven by big data when the type of data that's being used might be biased or unfair. So the recommendations that they made in 2022 was that there are some activities where privacy risk can't be appropriately mitigated. And so they thought, or their position is, that they should be prohibited before they cause harms in the community. In particular, profiling, use of profiling tools by law enforcement or insurance companies, etc., online personalization, and behavioural advertising that uses children's personal information. Now, this would be consistent with what's happened in Europe with the GDPR, something I will also speak about in a later video. Some of the recommendations are now law, but some of them aren't. And so thinking about the future of what the law might look like could also be relevant and useful to you in your assignment. So in the next video, I'm going to do a deeper dive into the APPs. In the meantime, questions, concerns, frustrations, compliments, suggestions, bring them on. Cheers.